Thank you, Madam Deputy Speaker. I rise to give the Scottish National Party's support to this group of amendments. Madam Deputy Speaker, much was promised of the Lords when this bill left this House, and many had deep concerns about the bill's intrusion on civil liberties and also the security of data. I regret to say, but I'm not surprised to say, that the Lords' amendments as a whole have not lived up to the expectations that some members of this House had. Whilst there has undoubtedly been some improvement in the safeguards afforded by the bill, and we intend to support those later, these came as a result of government amendments in the Lords, which largely arose as a result of opposition suggestions and suggestions from the Intelligence and Security Committee. But we don't think the amendments go far enough, and I'll give specific examples later. But at the moment we are dealing with this group of amendments which I think some people call for convenience, the Leveson amendments. And I want to knock quite firmly on the head any suggestion that the Scottish National Party or the Scottish Government are making any concessions in relation to the Sewell Convention. You would no doubt, Madam Deputy Speaker, be very surprised if we did, and we are not making any concessions. However, we are following, unlike the Minister who spoke earlier, we are following proper procedure as laid down in the Devolution Guidance Note number 10, which deals with post-devolution primary legislation affecting Scotland. And it states quite specifically, as I already said in my intervention on the Honourable Member for North East Somerset, it makes the following comments on amendments at paragraphs 17 and 18 of the note. And I'm going to read it in full, Madam Deputy Speaker, because it's very important. It says, during the passage of legislation, departments should approach the Scottish Executive about government amendments, changing or introducing provisions requiring consent, or any other such amendments which the government is minded to accept. Now, clearly this amendment is not a government amendment, and we've heard it's not an amendment which the government is minded to accept. But in that situation, Madam Deputy Speaker, paragraph 17 of Guidance Note 10 says it will be for the Scottish Executive, or the Scottish Government as it is now, to indicate the view of the Scottish Parliament. And then it goes on very importantly to say, Madam Deputy Speaker, no consultation is required for other amendments tabled. So it's not incumbent upon the Government to consult the UK Government to consult the Scottish Government about opposition amendments. And it also goes on to say, Madam Deputy Speaker, that ministers resisting non-government amendments should not rest solely on the argument that they lack the consent of the Scottish Parliament, unless there is advice to that effect from the Scottish Government. And I know, as a matter of fact, there is no advice to that effect from the Scottish Government, because I spoke with the Minister concerned at the weekend, Madam Deputy Speaker. Paragraph 18 goes on to say that the Scottish Executive, or Government as it is now, can be expected to deal swiftly with issues which arise during the passage of a bill and to recognise the exigencies of legislative timetables. For example, when forced to consider accepting amendments at short notice. Nevertheless, since the last opportunity for amendment is at third reading in the Lords or report stage in the Commons, the absence of consent should not be a bar to proceeding with the bill in the interim. Now, that's what the guidance note says. So the point made by the Honourable Member for North East Somerset is fallacious. This is not a government amendment or an amendment which the government is minded to accept. This is an opposition amendment. It is perfectly open for the SNP to support this at this stage without making any concession. It is only when the amendment, or in the event that the amendment is passed by this House, that the Government, it will then be incumbent upon the Government to go to the Scottish Government and the Scottish Parliament to get a legislative consent motion. So this, Madam Deputy Speaker, is a complete red herring. Yes, I will.
In the event that such a legislative consent motion were refused, would the Honourable Lady therefore expect the Queen to refuse the royal assent to the bill, because that would be the only way of stopping it becoming law?
Well, I can assure the honourable gentleman that we are not going to come to that event, because if this amendment is passed by this House, then the Scottish Government will be agreeing to, will grant a legislative consent motion to this, because the SNP, which is the opposition here at Westminster, and the Government in Scotland, has discussed this issue in detail over the weekend. I've discussed it with the Scottish Government Minister, and we have a position on the amendment, which I'm now about to set out, Madam Deputy Speaker. And I'm very conscious of the time, so I'm going to keep it as brief as possible. As I said earlier, this amendment from the Lords rides on the back of Clause 8, which I'm very proud to say arose from an SNP suggestion for amendment in the bill in committee. We've heard that the effect of the Lords' amendment, in my respectful submission, it's a good effect. No newspaper should be involved in telephone hacking, and if it is involved in telephone hacking, then it should face the consequences. Just to make the SNP position clear, Section 40 of the Crime and Courts Act, of which we've heard much in the Chamber today, was of course passed in March 2013 as part of implementing the recommendation made by the Leveson inquiry that any new regulator set up by the press should be accredited as independent and effective. And the purpose of Section 40 is to provide cost protection for claimants and Leveson-regulated newspaper publishers. It was passed in this House with cross-party agreement, including the support of SNP MPs who were there back in 2013, rather less, Madam Deputy Speaker, than there are now, but my colleagues supported the bill. And as has already been said, the Government have reneged on implementing Section 40 on many occasions, and today have announced a consultation further kicking its implementation into the long grass. Now, as has quite correctly been said, Section 40 extends to England and Wales only, because regulation of print media is devolved to the Scottish Parliament, and the Scottish Parliament have provided cross-party support for the UK Government's actions to implement the Royal Charter, and the Scottish Government will continue to monitor the current press regulations and work with other parties in Scotland and Westminster to ensure effective regulation of the media on a non-political basis. Now, Madam Deputy Speaker, the majority of the press, particularly the regional press in Scotland, were not involved in the sort of malpractice which prompted the Leveson recommendations. Therefore, it is the view of the Scottish Government and the Scottish National Party that any policy in this area in Scotland must be proportionate and must balance both the freedom of the press and also the public desire for high standards, accuracy and transparency. That said, the protection afforded by Section 40 when it's brought into force would be available to Scottish litigants who choose to sue newspapers based in England and Wales. Regrettably, Madam Deputy Speaker, there were a number of major newspapers based in England who were involved in the sort of malpractice which prompted Leveson, and it's right, therefore, that such protection should be afforded. The limited amendments which we are discussing today will not affect small or regional newspapers adversely at all, because they haven't been involved in phone hacking, and I assume they have no plans to become involved in phone hacking. So the Scottish National Party MPs today are going to support these amendments to provide cost protection across the UK for claimants and Leveson-regulated news publishers in claims for unlawful interception of communications, including phone hacking. Mr. Speaker, Madam Deputy Speaker, as a result of these amendments, I hope that some good at least will come from this bill's passage through Parliament in the event that this House is minded to support them. I want to be crystal clear that nothing I have said this afternoon involves any concession whatsoever about the primacy and the importance of the Sewell Convention, of course now enshrined in legislation. And if anyone has any doubt in that, they should go away and read carefully the guidance note from which I have quoted at some length this afternoon. Unlike the Minister and the Shadow Home Secretary and the Honourable Lady, but like the Honourable Lady who's just spoken, I've been with this bill since the beginning, and it's been quite an interesting journey. Mr. Deputy Speaker, as I said earlier this afternoon, much was promised of the Lords when the bill left this House. And as the Shadow Home Secretary has said, there were very considerable concerns when the bill left this House to go to the Lords regarding the intrusion on civil liberties by aspects of the bill and also issues relating to the security of data. It's a matter of regret that the House of Lords amendments as a whole have not lived up to expectations. However, there has undoubtedly been some improvements in the safeguards afforded by the bill as a result of the government amendments in the Lords. And although the SNP don't believe these go far enough, we will be supporting them because we feel that they improve safeguards in the bill. And the Minister has listed some of them. I'm particularly happy with the uptake of the recommendation of the Technical Advisory Panel, the imposition of some restrictions on access to bulk personal data sets, and the inclusion of the threshold for internet connection records. And I'd also like to particularly welcome the amendments to clause 233 tabled by the UK Government to ensure the Scottish Government will be provided with the means to engage with the work of the Judicial Commissioners relating to the devolved powers in Scotland. Yes.
Grateful to the Honourable Learned Lady for giving way, and I also am pleased to note that we share our sartorial choices Will she agree with me, however, that this legislation is absolutely essential, because without it there will be a legal vacuum because of the expiry of existing legislation?
I do agree that this legislation is essential, and I do believe it's, as the SNP do, that it's important to give the security services and indeed law enforcement necessary and proportionate powers. And I welcome, as I've said repeatedly in this House, the Bill's attempt to codify the law and to provide an enhanced oversight regime. However, I will not demur from the position which I've held throughout, which is that in some respects the Bill does not provide sufficient safeguards. The SNP and many other stakeholders mentioned by the Shadow Home Secretary remain very concerned about the allowance of significantly unfettered collection of and access to communications data, including internet connection records, and we also oppose the far-reaching bulk powers to acquire personal and private data of our constituents, while a proper case for the necessity and proportionality of these powers has yet to be made out. And Mr. Deputy Speaker, I consider it a matter of deep regret that when the review, David Anderson QC's review into bulk powers it reported not to this House, but to the House of Lords. And this House, the democratically elected and accountable chamber, has not had an opportunity to debate that review. Now, there are many, it's an excellent review so far as it goes, and I wouldn't dare to undermine much of what it says. It's what's missing from it that's important. It makes out a case that bulk powers can be of use to the state. What it does not do is address the necessity and proportionality of those powers. Those are matters which are yet to be addressed. We're not going to get to debate them here, but as the Shadow Home Secretary said, it is very likely that they will be the matter of litigation in the future and the subject of being addressed by courts, both within the United Kingdom and also within Europe, for as long as we have the sense to remain part of those European systems.
I'm grateful to the Honourable Lady for giving way. On the issue of proportionality, would she agree with me that this needs to be put into some sort of context, in that, as the noble Lord Rooker pointed out yesterday, the problem is we have a commercial sector with a large number of commercial providers who are busy harvesting data all the time in order to advertise things to us. And it's important to keep that in mind, since the powers that the state is taking to itself are similar in some respects, and in terms of trying to ensure that we have some level of proportionality, that needs to be borne in mind.
I would agree with the honourable gentleman that at some point this House needs to look at the mass harvesting of data by private companies. But there's a big difference between a private company harvesting personal data and the state. The private company does not have the coercive power of the state. That is the crucial reason why this bill must be scrutinised so carefully, and while I feel it is a matter of the deepest regret that the review in bulk powers has not reported to this House and not been scrutinised in this House. But I wouldn't wish the position taken by the Scottish National Party on this bill to be portrayed as irresponsible, because it's not. It's an attempt to make sure that the bill fulfils its purpose while still also being lawful and proportionate. And as was alluded to in the debate earlier this afternoon, the Scottish Parliament has indeed given legislative consent to those consolidating and enhanced safeguard provisions in the bill, so far as matters fall within the legislative competence of the Scottish Parliament. But at the same time as doing so, if members care to read the terms of the legislative consent motion, which I believe was not opposed by anyone in the Scottish Parliament, concern was reiterated about the potential impingement on civil liberties by internet connection record collection and bulk data collection. And also I'd like to correct something the Minister said about Liberty. Liberty have scrutinised this bill in detail. Liberty provided detailed briefings. Now, one may not agree with all of them, but they provided detailed briefings on every aspect of the bill. And I think it's unfair to say that they are mistaken about anything. They are absolutely right that all that the double lock system involves is that, in reality, the judge will simply correct that procedures have been followed. The Minister will still make the initial decision. Liberty are quite correct in saying that. Now, Mr Deputy Speaker, I said in previous debates that I wasn't going to use the phrase mass surveillance because I felt that was a bit too broad. I talked about the phrase suspicionless surveillance, and that's the problem with this bill. The SNP and indeed many others who have concerns about this bill believe that surveillance should be targeted and based on suspicion. There is a deal too much of suspicionless surveillance in this bill, even as amended.
I'm very grateful to the Honourable Lady. I listened very carefully to what she said about the double lock, but surely the point is this, that where the judge has the final say, then the authorisation will not be granted. It isn't that the fundamental change here which creates the sort of balance that both she and I wanted to see?
Well, I don't accept that the double lock goes as far as some of us would have liked to have seen the government to go by having full-blown judicial warrantry with the power to look at the merits as well as process. But I do accept it's an improvement on what was originally in the bill, and its inclusion is a great tribute to the hard work that was done both by myself and my honourable friend sitting behind me, and also by Labour members on the committee. If that opposition hadn't been so root and branch, then many of the government amendments that have finally been passed in the Lords would not be with us today. I give way again.
But look, we're all keen to claim credit here, but it was the government's position from the outset to have the double lock. Let's not forget that. And that important change was very much as a result of government initiative as well as the good intentions of members opposite.
Indeed, but the fine detail of the double lock, which enables the Minister to get up, the Solicitor General to get up and say that double lock goes as far as it does, was inserted by way of amendment during the passage of the bill. Now, I'll just make a little bit of progress and then I'll give way again, because I don't want to take up too much time. Mr Deputy Speaker, the Scottish National Party were very pleased during the passage of the bill through this House to offer our support to the Labour Party on its amendment protecting trade unionists going about their lawful activities. But what about protections for other activists and campaigners going about their lawful activities? What about non-governmental organisations? What about whistleblowers? My position is we shouldn't have unjustified spying on trade unionists, nor should we have on other activists. Whistleblowers can sometimes be very inconvenient to the government and to the private sector, but they fulfil a very important function and there is insufficient protection for them in this bill. Also on protection for journalists, it is true that significant amendments were made in the Lords, but it's important, Mr Deputy Speaker, that it be recorded today in this House that journalists have continued concerns over the proposals in this bill, and they feel that the safeguards for journalistic sources should apply across the different powers contained within the bill, rather than in the limited way that they currently do. And by parallel, whilst great progress has been made in the Lords in relation to the question of legal professional privilege, there are still those within the legal profession who have concern about the way in which the bill has approached legal professional privilege, and that the way in which it has been drafted may have undermined the central premise upon which legal privilege is based. However, credit where credit is due, significant progress has been made. And if I may just say, I spoke with the Law Society of Scotland this morning. They recognise that the government have come a long way, but they're still concerned about these somewhat controversial measures and are very anxious that there should be post-legislative scrutiny about how the legal professional privilege works in practice. I give way to the Solicitor.
I'm extremely grateful to the Honourable Lady. She's very generous. She would agree with me that for the first time legal professional privilege is averred on the face of legislation, which is very important, and that secondly, further amendments made in the Lords that were approved by people like the Noble Lord Panic, for example, now deal with situations where inadvertently legal professional privilege material has been obtained. So now we're covering even more areas in a circumscribed way and creating the sort of safeguards that I know she wanted to see.
Well, I read with interest the debates in the Lords about legal professional privilege, and I did note very carefully the approval granted to the measures by the Noble Lord Panic. But I also noted that the Noble Lord Paddock made the point that the Bar Council of England and Wales were still not entirely happy about the provisions. And that's a matter for them, but I think the suggestion by the Law Society of Scotland that there be very careful post-legislative scrutiny of how legal professional privilege works in practice should be adhered to. But, Mr Deputy Speaker, the two huge concerns I have about this bill still are in relation to internet connection records and bulk powers. I've already spoken about the limitations of how we've dealt with the bulk powers review and the fact that in my opinion, and that of many others, it doesn't deal with the issues of necessity and proportionality. But in relation to internet connection records, I do welcome the limited safeguards that the Lords have introduced, particularly the threshold increase on serious crime, judicial approval for data retention notices and prohibition of the retention of third-party data, which was something we were quite agitated about in committee. But it's a matter of regret that we still will have, when this bill is passed, provisions dealing with the collection of internet connection records which go beyond anything that any other Western democracy has on their legislative statute book and, as the Shadow Home Secretary said, may be of dubious legality. And the fight in this House, I think, in relation to our concerns about civil liberties in this bill has been lost. But as the Shadow Home Secretary suggested, it's likely that the fight will continue in the courts. And Liberty is representing the Honourable Gentleman in a legal challenge to existing surveillance laws. And as the Shadow Home Secretary said, the Government has ignored the opinion of the Advocate General in the Court of Justice of the European Union on these issues, because the Advocate General said that the current provisions for the collection of communications data lacked vital safeguards. And to my mind, Mr Deputy Speaker, that means that when this bill is passed into law, it will be open to immediate challenge. So really, just to summarise, the bill is certainly the better for its passage during the Lords. It pains me slightly to say that, as somebody who doesn't approve of the House of Lords, not because I don't approve of a second chamber, because I think the second chamber should be democratically accountable in some way. But it has improved in the Lords. But I do not believe, Mr Deputy Speaker, that what was promised of the Lords and expected by some on opposition benches in relation to the protection of civil liberties has really come to fruition. It's a matter of the greatest regret that peers supported the Internet Connection Record powers just hours after the Investigatory Powers Tribunal had ruled that the security agencies had been unlawfully scooping up personal confidential information on a massive scale for more than a decade. I was repeatedly told in relation to my objections about this bill that our security agencies are the best in the world and they never break the law. I suspect it's close to the truth that the British security agencies are, if not the best in the world, then amongst the best in the world, but they do sometimes break the law. Nobody is infallible. We must have safeguards that are real. And as I say, it is very noteworthy, and I think an indication of the inadequacy of the scrutiny of this bill, that it was only hours after the Investigatory Powers Tribunal had ruled that there had been unlawful action that the Lords supported the provisions on internet connection records in their totality. It does seem, Mr Deputy Speaker, that the battle is lost in this House, but in relation to the very real concerns that I and others have about the lawfulness of aspects of this bill, I suspect it may be won elsewhere.